This is the Trials Podcast, where we focus on the challenges the injured face and how we meet and deal with those challenges in litigating catastrophic injury cases. Today, I'm very excited to have our friend and colleague, trial lawyer Lee Gresham, on the program, and we're going to have a discussion that focuses on medical cases. There's some really specific and definite challenges and pitfalls that families face in these cases. One, you're oftentimes dealing with, or you're typically going to be dealing with, a permanent, life-altering, catastrophic injury or death. These cases take oftentimes, and in most cases, years of litigation. For example, a birth injury case that comes to mind is ongoing 4 years of litigation, 50 witnesses, multiple depositions, 10 medical experts. The burden of proof for the injured in these medical cases in Alabama is so high, it typically takes, again, years of litigation, multiple experts, the time, the cost, the expense of all the depositions and litigation expenses to get it there in order to prove the case. There's some specific proof requirements in Alabama. And so that's what we're going to be talking about today with Lee Gresham, and I would invite you to transition with us as we go to the interview with Lee. Lee, welcome to the Trials Podcast. This is the program where we focus on the challenges the injured face and how we meet and deal with those challenges, specifically in litigated cases. And I'm really excited to be here with you today. And I ask you to start off, if you could give us an introduction and tell us, what got you into law. I believe you played a lot of sports growing up, so I somehow feel like that was part of it. But if you wouldn't mind, give us an introduction.
Well, thank you, Aaron. Thank you for having me. I'm glad to be here, and look forward to spending this time with you. I played a lot of sports growing up. I'm not sure that had a direct impact on why I chose to practice law, but it's probably a longer story than anybody wants to hear as far as that's concerned. But when I got to college, I really didn't know what I wanted to do. Two things that I was good at was speaking and writing. And so I started pursuing a major in English toward that end. And then I started thinking, what am I going to do with an English degree? And I wanted to do something where I could utilize the things, my gifts, I guess, and also help people. And one summer when I was in college, I was a runner for a law firm, and it was a personal injury law firm in Birmingham, where I'm from. And so I just got to know, I kind of, heard the lawyers talking and just kind of got a feel for what was going on. And I think that pretty well cinched it for me that I wanted to go to law school. And it really pretty much shaped my career. I didn't know it at the time, but it made me want to be a trial lawyer or plaintiff lawyer, however you want to characterize those of us who represent people who've been injured, not just physically injured, but also economically or otherwise. And so, once I went to law school, I thought that everybody was like me, that they wanted to try lawsuits. And, I was confused when I heard people saying that they had no interest in being in the courtroom at all. That I want to, some people saying I want to be a tax lawyer. I can't imagine why anybody would want to do that. But anyway, that was not my anything that I was interested in. I wanted to try lawsuits and represent people who needed to be represented. And so that's kind of my background. I clerked for a law firm during law school, and got to know the practice even more. And then when I got out, I got hired by a plaintiff firm in Birmingham, and the rest is kind of history. As far as now, I've been practicing for I think 37 years or something like that.
Well, Lee, I had a somewhat similar experience, except I knew in college, I knew in high school, and really going back to middle school, I knew that I wanted to go to law school and be a lawyer. I really didn't know how I was going to get there. My dad, I appreciate you sharing that with us. My dad, I probably heard him say when I was growing up probably 1,000 times or more, son, get a good education and help people. And at times I thought maybe he was losing it a little bit, because this was a guy that I don't even think he graduated high school. I believe he got a GED, joined the Navy, worked and did a lot of factory work. And so at the time I thought that education would come in the classroom, and of course that's important, but in reality it came primarily from being around guys like my dad growing up that modeled that work ethic. But then also in law school, back in 1997, I went to work in a law firm. So in a lot of ways, that education, being around those guys growing up, then the thousands of cases, the thousands of lawyers and legal professionals that have influenced me, and you're one of those lawyers, and I'm so glad to have you here. Again, we focus on the challenges the injured face, and working with you helps us meet and deal with those challenges. So we appreciate you and what you do for us, what you do for our clients. And the topic, as you know, that we're excited to talk about today is medical malpractice cases. And I think you would agree with me, as far as injury law goes, in general, there's nothing more challenging than a medical malpractice case. Could you talk with us about, how you got into medical malpractice cases and the challenges involved in those cases?
Sure. I got into medical malpractice cases, I guess, grudgingly years ago. Was not really interested in them. I ended up trying a case with one of my law partners when I was a young lawyer, and it was a very difficult case. And at that time in the state of Alabama, where we are, it was very difficult to win at trial in a medical malpractice case. It is still very difficult, but it is. There's at least been some good verdicts that have we've been able to obtain in the last 10 years or so. But we tried this case, and it tried really well for us, and it came back with a hung jury. And I was thinking, you've got to be kidding me. We've got to try this case again. I didn't want to try it the first time. We ended up settling the case, and it worked out fine. And then for a number of years, I didn't handle medical malpractice cases. I was involved in some other complex litigation, environmental stuff. And then it just kind of organically happened again, where I just started getting calls on medical malpractice cases, and lawyers would call me and ask me if I was interested in these cases. And at first I was not. And then I took a case that I was really interested in, and it kind of just grew from there, where I handle a number of medical malpractice cases. They are very difficult cases. They're expensive. They're risky. But the amount of things that we see, the number of horrific injuries that we see as a result of medical negligence, they have to be accounted for. And it's not punishment, but it's accountability. And doctors and medical personnel have a responsibility to their patients. When they don't fulfill that responsibility or breach the standard of care, then I believe that there should be accountability there, particularly when you have, a horrific injury or death. I don't know if that answers your question, but that's kind of a long-winded answer of how I got involved.
No, Lee, I appreciate that, but it does bring more questions, of course. You mentioned risky, risky business, expensive. Why are they risky? Why are they expensive? What's involved? Can you kind of get us into the nuts and bolts of why it's so risky and why it's expensive, and what people that are facing these challenges and issues need to know?
Sure. One thing that I tell clients fairly regularly is what we believe and what we can prove sometimes are not the same thing. That's never more evident than in a medical malpractice case. I believe that this doctor should have done this, or this doctor should not have done this.
Or Lee, oftentimes, how many times have you heard, I went to another doctor that told me this should have been done?
Right. You hear that all the time, and then when it comes down to it, that second doctor is never willing to testify that he or she made that statement. But so the thing that makes these cases risky is that there is a fundamental acceptance of people in the medical field by juries. People tend to trust doctors and like doctors and respect doctors and nurses and people, all medical specialties. So taking the case and putting the money into the case, working it up, and then going to trial is risky because you have to fight against that. I won't call it a bias, but that general acceptance of doctors and nurses. But there's also the financial risk, and that comes with there are three elements in a medical malpractice case. You have damages. Somebody's been damaged by what they think is medical negligence. And then you have a breach that we believe is the thing that caused the damage, the breach of the standard of care, which is what a reasonable doctor or nurse in the same or similar situation would have done in that instance. And then you have, which is the hardest hurdle, causation. You have to prove that the breach caused the damage that you're complaining of. So to do that, the only way we can do that is through expert testimony. That's required under our law in the state of Alabama. That we have to have a similarly situated physician or nurse offer an opinion to a reasonable degree of medical certainty that there was a breach of the standard of care and that breach caused the damages complained of. And that's where the great expense comes in, because and I'll share in a few minutes when we talk specifically about fetal distress cases, why that is such an expensive endeavor.
Now, Lee, you talk about damages. Just so we're all on the same page, you mean the injury suffered. Now, there could be some economic damages as a result of that, but the heart of it in the medical case, the proof is some type of injury, whether it's a brain injury, spinal injury, or some other type of permanent injury.
That's right. Yeah. And, the most egregious examples that people think of were, I went in to have my right leg amputated below the knee, and they amputated the wrong leg. That's those type things happen. Thankfully, they don't happen very often. I think those type things you rarely see anymore. But yeah, that's right. That someone goes in for a medical procedure, and or it doesn't have to be a procedure. There might be a misdiagnosis. It might be a over medication. It might be a failure to treat. There are all kinds of aspects of a medical malpractice case that are potentially actionable that you could bring a lawsuit on behalf of. But you really have to be careful in the cases that you select because, if you, well, first of all, straight out of the gate, if you can't meet the three things that I just talked about, damages, breach of the standard of care, and causation, then you're dead. You're dead from the start. And in my mind, in our firm, we try to be selective in the cases that we take. There really has to be clear liability, and which is pretty bad conduct, pretty egregious. This is an obvious breach of the standard of care, and there has to be a severe or permanent injury or death as a result of it. And so anything else, those cases still are risky and expensive, but that helps minimize the risk. And I always try to get my experts on board before I file the case, so I know exactly what I'm dealing with. I know exactly what they're going to say. Of course, they don't know all the facts at that point, but they've at least examined the medical records and can give me an idea of what they think.
So, Lee, before we talk specifically about birth injury cases, let's back up and talk a little bit about you've mentioned the elements of a medical malpractice case. So, as a lawyer for the injured or for the family of a deceased that's been impacted by a medical case, how do you, as a practical matter, go about meeting that burden of proof? How do you go about, generally speaking, proving the case? What's your responsibility as the lawyer representing an individual or a family?
Yeah, so typically I'll get a call from a lawyer or from a person who's been affected or their family member's been affected. It's important that you get all the facts. What happened, when did it happen, how long do you have left in the statute of limitations, which is 2 years from the date of the incident, or 2 years from the date of death. And then you have to get the medical records, all the records that show exactly what happened. And then, once I get the records, I go through the records, and then I'll also have an expert in whatever the medical specialty is at issue to review the records and tell me what their opinion is. Over time, I've gotten to the point where usually the expert says what I expect him to say, yes or a thumbs up or a thumbs down. I can usually predict that, but not always, but that's why you have an expert in the first place. And then I really counsel with my clients about, here's what it's going to look like, and what a deposition is, and what discovery is, and why we have experts, and why this is going to take 18 months or 2 years, and that sort of thing. And sometimes you have to have the hard conversation. In fact, you and I have been on a call before with a potential client where we had to say there is no breach of the standard of care. We hate it. What we believed, we can't prove, and sometimes you just have to have that hard conversation. I take that as part of my job, though. It's my job to give an honest assessment to a prospective client, even if it's not the news that they want to hear.
Now, Lee, when you talk about bringing in experts to review a case, to review records, and sometimes go further than that, the expert is looking for a breach of the standard of care, and then it may be a different expert or it could be the same depending on, like you said, the medical specialty or the injury involved, but that the breach of the standard of care resulted in permanent injury or death. But then also, at times, aren't you bringing in experts if there's some kind of future medical treatment needed, if there's economic impact? So oftentimes, when you're going back to the cost and the risk, these, oftentimes, don't you have multiple experts involved?
You do. And I don't know if you want to segue, if it's okay if I talk about a birth injury case, but I think it's probably the best example of the use of multiple experts. I've got a case ongoing now where, if I can remember everybody, I've got the experts that I have that are retained experts in the case. I've got a obstetrician who is talking about the OB's breach of the standard of care in the delivery of this child, the labor and the delivery of this child. I've got a labor and delivery nurse who talks about the breach of the standard of care for the nurse involved in the labor and delivery, particularly as it pertains to reading the fetal heart monitor strips, which is looking at the heart rate of the mother and the unborn baby in utero. I've got a neonatologist who has opinions relative to the care of the child after the child was born, the resuscitation efforts on the child. I have got a physiatrist who is a physical medicine doctor who his area is to look at all the aspects, the medical records, interviewing the doctors, observing the child, and then making determinations relative to the child's ability to work, the child's ability to earn a living, the child's ability to function in society, and then to attribute cost to the care of that child for the rest of the child's life, and to look at what is the child's life expectancy with the disability. And then I've got an economist who will take the physical medicine doctor's testimony and reduce it to present value for what is all of that worth in today's money. And then finally, I've got a vocational expert who talks about whether the child is in fact able to work or earn, which basically supports what the physical medicine doctor testified to as well. So, that's all of those experts are in one case. You could also have, in some cases, you might have a neuroradiologist in a baby case, a fetal distress case. You might have a pediatric neurologist. You might have a placental pathologist. So there are all kinds of potential things that could surface in one of these cases. So, and here's kind of a rule of thumb. If the plaintiff, who I represent, has 4 experts, for example, the defendants will have 6 or 8.
Yes.
That's just the way it is. It's an arms race in terms of experts. We try to get the most qualified experts in the country, and to support our case. And of course, the defendants will always find somebody that disagree. That's just the nature of it.
Lee, wouldn't you say that oftentimes television and media often portrays cases as if the injured have all the advantages, and in reality, isn't it fair to say in medical cases, the insurance carriers, the hospitals, the medical providers essentially have the advantages? Wouldn't you say the deck stacked against the injured in medical cases?
Yeah, 100%. First of all, the plaintiff has the burden of proof. The defendant doesn't have to prove they're innocent. We have the burden of proof, proving that they breached the standard of care and that they caused whatever damage we're claiming, which is difficult. And there are legal battles that have to be fought within the case. They might file what's called a motion for summary judgment, saying that you can't meet your burden of proof, and here's why. And so if the judge grants that motion, then the case is over. You never get to a jury trial. If you do get to a jury trial, you present all of your evidence, and then the defense will always file a motion saying that you didn't meet your burden again at trial, and the judge has the opportunity to rule on that. If he grants their motion, case is over. If you survive that, then the defense presents their case, and then the case goes to a jury, in which case, if you get a verdict, then the defendant almost universally will appeal the verdict, particularly if it's a sizable verdict. So you have to go to, the appeals court. In our case, in our state, it's the Supreme Court of Alabama, and try to keep your verdict there. So it is very much an uphill climb for the plaintiff.
Thank you for listening to part 1 of our conversation with trial lawyer Lee Gresham on the Trials podcast. We've covered the foundations of medical malpractice, the burden of proof, the cost and risk of litigation, and just how steep the climb can be for injured families seeking accountability. In part 2, we go deeper into birth injury cases specifically, what goes wrong, what families need to know, and the practical steps to take if you think you have a case. Subscribe now so you don't miss it, and we'll see you in part 2.